I'm Sandy Gage. I was president of what was CAALA back in 1973. A little background would be helpful here. The organization grew out of a group called the Plaintiff Trial Lawyers. And at the time that I was membership chairman, some years before I was president, we had about 150 members. And judges were not particularly enamored by the organization. It was hard to get them to come to our events. The organization grew to over 1,500 at the time I was left as president, and the name changed to LA Trial Lawyers. We gained a lot of respectability, a lot of credibility, and did a tremendous amount on behalf of consumers. During the years of my presidency and around that period of time, probably the major issue that we had to deal with was at the legislative level. And there, our organization participated with the state trial lawyers and other groups to fight no-fault insurance. And some of you may recall, but the concept was that in automobile accidents, unless they were of great magnitude, there would be no damages recoverable for the personal injury itself. Only the medical bills would be paid. And we came within just a few votes at the state legislature of defeating that pernicious program. This was very significant. We had our own public relations person. The organization grew, and we did a great deal on behalf of making it important to protect consumer rights. One of the things about which I was particularly proud was a change in format during those formative years. I started what was then the LATLA Advocate, and today I'm really proud to see how it's grown and developed into a major publication. The purpose was to inform and educate our members, not just tell them about meetings. And one of the things that we did was to ensure that copies of our newsletter went to all of the judges, I believe state and federal, so that we could educate them along the lines of the issues that we were dealing with in our publication. The other thing that I felt was important, we changed the format from just having one speaker at a monthly meeting that might be half hour, 45 minutes of a presentation, to large-scale seminars where many, many of our members got an opportunity to present their information, their point of view, and their experience, and to bring that home to all of us so that we all benefited. And I cannot think of many organizations where there was such a wonderful degree of sharing of information. And today that's even been improved with the meetings dealing with arbitrators, mediators, and judges, that they're evaluated. And this provides something to provide a level playing field for the trial of cases and the presentation of matters at arbitrations and mediations.